In the fall of 2020, a group of citizens from Chicago's southeast side sued to stop a metal recycling plant from moving into their neighborhood.
The southeast side is earning another pollutant in their community. That's not acceptable. That is immoral and that's wrong.
The plant was known to spew metallic dust from scrap piles into the air. Furious about the relocation from a mostly white neighborhood on the north side to their majority Latino community, the residents argued the move violated their civil rights.
Because of the amount of industry that is concentrated along the Calumet River on a daily basis, you will smell foul odors. They burn your eyes. I suffer from severe asthma. On days like that, I have to go inside. This is another way that we are treated like subhuman.
But a judge denied the request. Her reason? They couldn't prove intentional discrimination was involved in the decision to move the plant. Proving intentional discrimination is a high bar that was put in place by a 2001 Supreme Court opinion authored by Antonin Scalia. But we'll get back to that. From Flint, Michigan's contaminated water supply to Cancer Alley in southern Louisiana, communities of color and low-income communities across the country are disproportionately affected by pollution. The movement to address these disparities has a name: environmental justice.
Environmental justice will be at the center of all we do addressing the disproportionate health and environmental and economic impacts on communities of color.
The Biden administration has pledged to make environmental justice a priority. And a few states are creating new laws that give disadvantaged communities the tools to combat negative environmental impacts. So when it comes to environmental justice, what real legal protections are there? The roots of environmental justice date back to Jim Crow. Discriminatory policies like redlining segregated millions of Americans into neighborhoods that were then targeted for landfills, incinerators, and other toxic facilities. When giving permits to heavy industry, regulators often failed to account for pre-existing pollution levels. The cumulative impact of multiple toxic facilities on a neighborhood's environment can have tragic consequences.
In 2020, the places where you find highest incidence of COVID, highest mortality of COVID, were again in largely Black, Brown, and indigenous communities. And that's no surprise. Those are some of the areas of worst air pollution.
We will not allow one county to become a dump site.
It took a wave of protests in the late 1970s and 1980s to finally force the federal government to recognize environmental justice as an issue that needed attention.
We've come to Washington, D.C. to catch the attention of the president and the government and all forces that be.
In 1992, under President George H.W. Bush, the Environmental Protection Agency created the Office of Environmental Justice. And in 1994, President Clinton signed an executive order requiring the federal government to address environmental justice in communities of color and low-income populations.
Executive Order 12898 made environmental justice the mission of every federal agency in the United States.
Cliff Villa is an environmental law professor at the University of New Mexico. Before that, he spent 2 decades at the Environmental Protection Agency, enforcing federal environmental regulations. He says that progress on environmental justice at the federal level has stalled since the 1990s.
That mission has come and gone in emphasis with various presidential administrations.
The lay of the land for law for environmental justice is sort of hit and miss. We don't have a national U.S. environmental justice law.
As a result, communities looking to get let out of their drinking water or push back against a hazardous waste site have had to find other legal options.
There are a number of federal environmental statutes that allow advocates to pursue environmental justice. So, for example, in response to the drinking water contamination in Flint, Michigan, there were citizen suits against the state for violation of the Safe Drinking Water Act.
Another option invokes civil rights laws, like the 14th Amendment's Equal Protection Clause and the 1964 Civil Rights Act. But as the residents of Southeast Chicago learned, there is a 2001 Supreme Court precedent blocking the path for many plaintiffs arguing cases rooted in discrimination. That case, which had nothing to do with the environment, was about whether the state of Alabama was discriminating against its Spanish-speaking citizens by requiring them to take their driver's license test in English.
We hold that there is no private right of action to enforce disparate impact regulations promulgated under Section 602 of Title VI.
What the Supreme Court decided, 5-4, in a majority opinion by Justice Scalia, is that in order to bring that case in court, the plaintiffs had to prove not only that the state discriminate, but they intended to discriminate. Intent to discriminate is a very high burden to prove.
Since then, all lawsuits centered on civil rights claims, including environmental justice cases, have had an uphill battle in court. So, what options are left? A big one is Cliff Villa's old agency. Critics say the EPA doesn't have the best track record on environmental justice, but that may be changing.
Environmental activists are celebrating a decision by the Chicago mayor, Lori Lightfoot, to delay the permitting process for General Iron.
The decision comes after the Biden administration's new EPA administrator, Michael Regan, sent a letter to Lightfoot concerned about another possible polluting business coming to an area that has been plagued with environmental hazards.
That was a huge victory for the community because we were on pins and needles. This was going to be permitted any day now. Literally, this happened at the last final hour.
The plant is on hold, for now, pending further environmental review. But in the midst of a national reckoning over race, the Chicago decision may be an early salvo in the Biden administration's attempt to address environmental justice.
You're going to see them reaching out, providing grants to these communities where there's money, making sure that they're bringing these communities to the table so that they have meaningful involvement.
Still, unless Congress enacts a law, these changes may be tenuous.
One of the big concerns with President Clinton's executive order was that was more than 25 years ago. And what happened was the issue came and went, and from a results standpoint, there really has not been the kind of progress that we might have expected.
I have 2 children and I want the best for them. That is my goal in life, to be able to do something that is going to improve the quality of life of people on the Southeast side.